Head of Business Development from today's sponsors, Rix and Kay. I'll hand over to you now, Scott.
Thanks, Nigel. Yes, Scott Garner from Rix and Kay. I'm Head of Business Development. I'm just going to run you through a very quick overview of Rix and Kay and Cloisters and a little bit of housekeeping before we move on to the session. So just bear with me for 30 seconds or so. So Rix and Kay, for those of you who haven't heard of us, we're a full service law firm. We have coverage across Kent and Sussex. Our main offices in Kent are based in Sevenoaks and Ashford. In Sussex, we have offices mainly based in Brighton and Hove and Uckfield. We're a full service law firm, like I said, providing a full suite of legal services to businesses. And sitting alongside that, we have an extensive private client offering, providing legal services to business owners, directors, of course, and individuals and their families. We're delighted to be joined by Cloisters Chambers, a set of barristers in London, and we'll be hearing from Adam Oringer a little bit later on, who's going to talk to you a little bit more about the details of enforcement of restrictive covenants. Before we hear from Adam, I'm going to pass over to Victoria Reagan, who's going to take you through an overview of restrictive covenants and what that means for businesses and business owners particularly. And then right at the end, we'll hear a little bit from Joe. Joe's IoD Senior Policy Advisor. And he's been working on the IoD's response to the government's consultation on restrictive covenants, which I believe is now closed, and we're waiting the formal response from government. I'm sure that'll be a little while, but Joe will provide us with an update on that. Before I do pass Victoria, just a little bit of housekeeping very, very quickly. The session is being recorded, so we will make that available to everyone who's registered for today. After the event, and we will be doing a live Q&A at the end. So if you do have any questions during the session, then use the chat function at the bottom of the Zoom screen, post your questions and we'll pick them up at the end. Or indeed, just put your hand up at the end if you want to ask a live question to any of the panelists at the end of the session as well. So that's it from me. I'm going to hand over to Vicky now, who's going to the session.
Great, thanks, Scott. So we just have the next slide, please. So just by way of overview, welcome everybody to today's webinar on post-termination restrictions. To begin with, I shall be looking at the different types of restrictive covenants or post-termination restrictions that you may find in employment contracts, and also just to look at some key considerations when reviewing and drafting. Then Adam will be putting these into practice and looking at the enforcement procedures and alternative protections. And Joe will be talking about the recent consultation on the proposed reform of non-compete clauses. Next slide, please. So post-termination restrictions are typically clauses which prohibit an employee from competing with the next employer, so from taking confidential or competing information, and then once they've left, using that. So it's to try and prevent them from taking customers and business and information that they may have learned about whilst in employment. So it's vitally important to have post-termination restrictions in an employment contract so that they are expressed. They will not be implied into contracts. They're essential for the protection of business and customers and clients, to restrict the use of information when people leave, to prohibit competing, to prevent damage to company, and to possibly deter an employee from joining a competitor, and perhaps to deter a new employer who may also be find themselves in court and defending legal action if they're found to have been in breach or have found to have been inducing a breach. Next slide, please. So there are different types of post-termination restrictions. So taking each in turn, we've got the non-compete clause. This is probably most difficult to enforce, but this really is the gold standard. And if enforceable, it's been termed the most powerful weapon in an employer's armory. So in essence, this is trying to stop and prevent an employee from joining a competitor or setting up their own rival company. It's not simply for preventing competition outright, and you really have to have a reason as to what you're trying to protect, and also from preventing the employee from taking advantage of particular information. So to justify and to try and seek enforcement of such clauses, you should be able to claim, well, actually this confidential information is so integral to the business that it would cause so much damage if that particular bit of information is used. Also, perhaps looking at if the person is more senior, they may have had more access to trade secrets and perhaps more influence over clients and customers. Or indeed, if your business is highly specialized or niche. Next slide, please. So non-solicitation clauses. And so these are really the prevention of an ex-employee from directly contacting or soliciting clients, customers with a view to obtaining business. So it's a positive act of contacting and making that initial approach. So whilst they can inform people that they're leaving and also where they're going, there is a fine line between that sort of acceptable communication versus unlawful solicitation. So the distinction being, there's a difference between saying I'm leaving and this is where I'm going. But then if they say, well, actually, and I'm here, I can be contacted, do contact me at this number so I can continue working with you, that's what tilts the balance. So it's really, there has to be this invitation to transact business. Within these clauses, they're also restricted. So ordinarily, preventing them from contacting customers, clients with whom that particular individual has had dealings or contact with. And also they'll have a look back or a backstop period. So ordinarily it will be preventing with whom they've had contact and dealings with over the last 12 months before termination or before departure. It would be very unreasonable to try to say that it's actually everybody's contact within the company, even if that individual has not dealt with that person, or indeed to say anybody for any period, especially if those people have long left the business and giving their business to the company. There may well also be issues when employees say, well, actually, I've come with my own following. These are my own contacts. And as such, then they're excluded from non-solicitation, they're mine. Well, quite frankly, unless that's been expressly carved out, or particular companies and clients, etc., have been carved out within an employment contract at the outset and agreed, this will not be implied and they will not be exempt. Next slide, please. So restrictions relating to customers and clients can actually be extended to cover not only the active steps, the enticement by the ex-employee, but also in the provision of services where there has been no active steps by the employee, but rather where the customers or clients have actually approached the ex-employee. Enforcement may be more likely. You can establish that there's been a very close personal relationship between the employee and the customer or client, and that if such a clause was not enforced, it would expose the business to significant risk. It's also more likely that these clauses may be enforced in circumstances where it's difficult to police non-solicitation clauses. But essentially, you would be depriving innocent third parties from their freedom of choice, and therefore the courts take a more cautious approach. So with non-poaching clauses, this is where essentially you're preventing former employees from soliciting or poaching staff or teams, which could be incredibly damaging. So the justification here really is that you want to maintain the stability of the workforce, but do take some time to think about which employees that you're trying to protect and preserve. It can't apply to all employees of all rates in the hierarchy. So really just think about maybe the level of expertise or the level of seniority and with whom that employer worked. We're also seeing an increasing trend in team recruitment and team poaching. And so with this, clients are asking more for clauses that prevent a team move. So an anti-team move clause, we call these like waiting room or departure lounge clauses. So effectively, the employee has to sit in the waiting room for a set period, say 6 months before leaving. So essentially, they can't all be leaving at the same time. Little bit untested, so arguably they may be deemed to be overly restrictive over time, but it would serve as a good preventative at the very least. Next slide, please. So geographical restrictions are those which prevent employees from carrying out activities within a radius around the premises, and generally speaking, becoming a lot less common now, but the larger the area, the radius, the more difficult to try to enforce. And I say probably not as much in favour nowadays, and actually in respect of the lockdown, where people have been home working, and it's really shown that we don't really need to rely on a physical presence, and also the use of electronic communications. But that said, they do have a place, and they're still appropriate for certain types of businesses that really do rely on local goodwill, such as hairdressers, for instance. However, for businesses that are associated with a particular area, such as financial services in the City of London, you may not be able to restrict them operating in that area, because essentially you will be preventing them from working outright, and that would then be deemed a restraint of trade and would be unenforceable. So when assessing the enforceability of geographical restrictions, it's always good to consider whether there is an actual relationship between the interests to be protected and any specific geographical area and the area of activities. Where are the clients? If you only work in London, is it really necessary to have a restriction that covers the whole of the UK, for instance? Also look at the size, nature and density of the population of the area. More densely populated urban areas probably warrant smaller geographical restrictions. Next slide, please. With the exception of confidentiality restrictions, post-termination restrictions all should be limited in time. They'll obviously be dependent upon the nature of the business and probably the degree of customer goodwill and loyalty, but this will need to be considered. So also think about the time it will take for a replacement employee to come in, settle in and cement relationships with those customers and clients. But also think if there's an actual specific shelf life, if you're trying to protect confidential information, after which that information becomes obsolete anyway. Think about also the frequency of contact that the individuals have with the clients. Is it regular, or indeed is it only on an annual basis? For instance, in the insurance world, and renewal of annual premiums. In circumstances such as that, it may warrant restrictions which are covering 12 to 13 months. Just a word of warning, if you have high staff turnover, short notice periods, then it may well be jolly difficult to try to argue that if you're trying to enforce a non-poaching clause, that this is to maintain staff and the stability of the workforce. So as Adam will discuss in more detail, it's important that they go no longer than is necessary to protect the particular legitimate business interests. When I discuss this with clients, I think it's always helpful to maybe apply different timeframes for different covenants. So it's not just one template, one size fits all, but perhaps to apply a bit more thought into thinking, well, if you've got a lengthier non-solicitation clause, then you might be happy and prepared to consider a lesser amount of a duration of time for non-dealing, less for non-compete, and less for non-poach. And then once you've gone through that process, I also suggest that they pop it all down and have this written rationale, pop it in the file, just to show that you have applied your minds to this, just in case you need to show this. Next slide, please. And so to conclude, just a few more considerations when looking at post-termination restrictions. It's really important to bear in mind that the reasonableness of a post-termination restriction will be judged at the time when the employee entered into the contract, not the position that they hold at the end of the employment relationship. So if it was deemed, or if it's viewed unreasonable at the time of entering the contract, this will not then be saved by a promotion because it will be deemed invalid at the outset. Just another reminder really, just to make sure that you do update your covenants as well with any promotions and moves. Another consideration is to whether you would wish to apply a reduction for any time spent on garden leave against and set off the period of the restrictive covenants. And also do bear in mind that restrictive covenants will not be enforceable if an employer has fundamentally breached the contract, or indeed if employees can prove constructive dismissal. Those covenants will fall away. And if you're considering introducing termination of restrictions later on in the employment relationship as opposed to at the start, when you do introduce these, it is also necessary to have some form of consideration payment. And then finally, do make sure that your covenants in the contracts are signed by the employee and returned, so you have that unequivocal consent. The onus really is on the employer to show that these have been accepted, and the best and easiest way to do this is just to show the signed contract. So thank you very much for listening, and I shall now pass you over to Adam.
Thank you very much. You've heard from Vicky about the different types of post-termination restrictions and how they can be introduced into an employment contract. It's quite clear from what Vicky has said that the restrictions are very powerful. They're powerful for the business to protect its property and its customers and its trade secrets, but it's also powerful against the employee, because a restrictive covenant can stop someone from working and can stop them from earning a living. And it's quite easy to see how the covenants can also be open to abuse. For those reasons, the courts have introduced various rules and principles which they apply to ensure that post-termination restrictions can only be enforced in certain and appropriate circumstances. And that's what I'm going to be looking at in this part of the talk. Juliet, next slide, please. So the starting point in terms of the law is that the restrictive covenants are not enforceable. There is a presumption that they are an unjustified infringement on trade. A restrictive covenant can infringe on a person's personal liberty, can prevent someone from earning a living, and it also can have a disruptive and possibly unfair effect on competition in a particular industry. And so the courts have disliked restrictive covenants for a good 200 years and have set up a body of rules to ensure that they can only be enforced in particular circumstances. The touchstone for all of these rules and principles is proprietary interests. And so the courts are always keen to see if the business is using the covenants to protect its proprietary interests and nothing more than that. Next slide, please. And in deciding whether a covenant will be enforced, the courts apply this three-stage test. You've got that on the slide there, and I'll just give you an example. A typical example might be a restriction in the contract for an estate agent. And a typical restriction might say that the estate agent, after termination of their employment, should not set up another estate agent within a 10-mile radius for a period of 12 months. So how will the court address that type of restriction? Well, the restriction can be readily understood. So part one of the test can be met. And the court will then say, well, what is the legitimate interest which the original employer is trying to protect? Well, in the case of an estate agent, the interest will be its goodwill in the local area, its connections with clients, and its connections with potential buyers. So you can see there that there is a legitimate interest which requires protection. Then we move on to the third part of the test. Is the restriction no broader than reasonably necessary? This is where many restrictions fall down. So if the estate agent only has a business impact over a 5-mile radius, for example, a estate agent in a dense city area might only be involved in its most immediate neighborhood, a court might find that a 10-mile restriction is unnecessarily wide. Likewise, if a business has a fast turnover of customers, with customers often going to other businesses, a court might find that a 12-month restriction is unnecessarily long, because a 6-month or even a 3-month restriction would be sufficient to protect the employer's interests in maintaining its relationships with its existing customers. Next slide, please. Now, the legitimate interests which the courts will allow a business to protect normally fall into one of these 3 categories. I did a case not long ago involving a beauty salon. In that case, we're able to enforce restrictive covenants against employees because we showed that the salon had strong and important client relationships. It benefited from goodwill from being in a prominent position in the town centre and having been in that location for a number of years. And they also had a pool of employees who themselves nurtured client relationships. And the court found that and agreed that all of those were legitimate proprietary interests of the business, which the business was entitled to protect. And when an ex-employee set up a rival salon round the corner, taking with her clients and employees, the court was quite ready to enforce the restriction by making an injunction to prevent her from taking that step for a period of 6 months. Next slide, please. But having said that, the courts are still hesitant. They will not order an injunction just because there is a covenant in the contract. The courts are very alert to the fact that covenants are sometimes used by employers, by businesses, to stifle competition. Sometimes covenants are used to prevent another business from having an advantage. And the courts are very reluctant to be used in that way. Next slide, please. And so if you're faced with a situation where an employee has left the business and is threatening to breach their covenants, or conversely, if you're in the situation where you have taken on a new employee who may be in breach of their covenants in coming to you, then you should be aware that the enforcement procedures come in 3 parts. And the first part is an exchange of correspondence pre-action, trying to resolve the dispute without going before the courts. The second part is the interim court stage, where parties will start court proceedings and seek an interim injunction to prevent the employee from breaching the restrictions. And then the third stage is the full and final court hearing, where the court will decide who was right and who was wrong, having heard all the evidence. and whether the parties are entitled to damages as well as an injunction for breach of any of the restrictions. Now, we're looking here at the first part of the process. And this is often as far as any dispute will go. You'll have an exchange of angry letters, often from solicitors, demanding that the miscreant employee abides by their restrictions, and often seeking written undertakings, promising that they will abide by the restrictions. Now, if the employee confirms in writing that they will abide by the restrictions, that isn't in itself enforceable. But if they do give that sort of promise and then they breach it, then a court will have very little patience with them if it goes on to the next stage. Next slide, please. And the next stage is where a claim is issued, normally in the High Court, because the parties can't resolve the dispute purely in correspondence. Claim may well be against the employee who's breached the restrictions, and may also be against a new employer if it is said that the new employer should have known about the restrictions or has benefited from the breach of the restrictions. And once the claim goes in, you'll often find that there is an application for an interim injunction to enforce the restrictions until a full hearing. And there will often then be negotiations about undertakings as well. Now, undertakings are made to the court, and it's a way of avoiding an injunction. A party can say, well, I don't want to go before the court. I'll give my undertakings to the court that I will comply with the restrictions. At this stage, an undertaking to the court is enforceable. It is enforceable just in the same way as a court-ordered injunction is. And therefore, if someone gives an undertaking and breaches it, they are potentially in contempt of court. Most cases end at this stage with the parties giving undertakings. Occasionally, the case will go before the judge, who will decide whether to make interim injunctions. But one way or another, most cases peter out at this stage because nobody has the interest to go on to the part 3 of the process. Next slide, please, Juliet. Sorry, next slide again, please. Which is the trial of the claim. Normally, this is many months after the dispute has started. It can be many months after the restrictive covenants have actually expired. At this stage, the court is interested in deciding who was right and who was wrong in the final analysis, whether the interim injunction was correctly granted, whether damages need to be paid for breach of the restrictions, and whether the parties should pay costs. Costs are important because you will find that by the time cases have got to this stage, the underlying dispute is history, but the parties have expended so much energy, time, and money on the dispute that they end up fighting about who should pay for that more than the actual substance of the disagreement that brought them to this stage. Next slide, please. And this brings me on to some salutary lessons which arise from litigation about restrictive covenants. The litigation takes place in the High Court. That's a serious matter. The stakes are very high, and the claims are very, very hard fought. It is an aggressive type of litigation in most cases. And the costs in taking a case or defending a case can escalate very quickly. For that reason, many businesses will not take a dispute to court. Often the stakes are just too high considering the underlying subject matter. However, there are cases where the restrictive covenant does need to be enforced, and where the breach of the covenant or threatened breach of the covenant is really very serious. And in that situation, where there is no alternative, going to court might be the best way forward. Next slide, please. Having said that, restrictive covenants, although being very powerful and very useful, can be subject to abuse. You do often see restrictive covenants appearing in the employment contracts for very junior members of staff. I've seen many cases where businesses have put the same restrictive covenants in all the contracts, from that of the CEO to the porter or security guard or receptionist. That is likely to be seen as an abuse. Sometimes you see businesses threatening to enforce restrictive covenants, more in a fit of pique than because there is any legal basis for that threat. If people have left the business in acrimonious circumstances, or if people leave the business to go to a competitor, and there's a feeling of sort of unhappiness that they've jumped ship, then some businesses will seek to enforce a covenant just as an act of revenge. I've seen many battles over restrictive covenants start as a proxy, really, for an underlying battle of egos. I mention that because I want to caution against being seduced into that type of situation. It's very easy for a dispute to start for the wrong reasons, and it's very difficult then to back down when reality kicks in, or indeed a sense of perspective. Next slide, please. And so if you are faced with a situation where the enforceability and the enforcement of restrictive covenant is in question, whichever side of the dispute you're on, it is very important, in my opinion, to get impartial legal advice early on. It's important to do that so that your legal position can be ascertained from the very start, and so you have an independent and objective view about the pros and cons of engaging in litigation. As I say, once the litigation starts, the stakes and the costs escalate very quickly, and it can then be very difficult to find a defensible way out of the case. The next slide, please. The other advantage to taking legal advice at an early stage is that there are many alternatives to engaging in these difficult battles to enforce restrictive covenants. If an employee is believed to have taken a client list, then you may well be able to rely on a breach of confidentiality to make your claim. If the employee has used his position within the business to make preparations to set up a competitor business, that may have been a breach of that employee's fiduciary duties or duty of fidelity. There are many remedies available if an employee has stolen company data. And as Vicky mentioned earlier, a garden leave clause in the contract is much more easily enforceable than a restrictive covenant, and in many circumstances may give you just as much, if not more, protection than a restrictive covenant. And there are times where you can easily enforce a garden leave clause to protect your business, where you'd really struggle to enforce a restrictive covenant. Next slide, please. And so that was a whistle-stop tour of the legal principles. As I've said, those are principles that have developed in our common law over the last 200 years. In fact, probably have developed in our common law for far longer than that. It's quite clear from, I hope from what I've said and what Vicky has said, that many of the rules and principles don't really apply very easily to the modern way we work, don't really apply very easily to modern industries. The rules were very much designed to protect businesses within their geographic location, where there were only a certain number of businesses within a particular industry, within a particular place. Of course, the world has changed dramatically since then. And partly for that reason, the government has set about a consultation, a review of the laws about restrictive covenants. And on that note, I'll hand over to Joe now, who's the IoD policy advisor and drafted the IoD's response to the government consultation.
Thank you very much, Adam. Thank you very much. Hi, everyone. It's great to be here with you today. My name is Joe Fitzsimons. I'm a senior policy advisor at the IoD. And I'll just very briefly talk about the government's recent consultation on reform to the use of non-compete clauses. So originally there was actually a review in 2016, and this found that post-termination restrictions were working well and that everything was okay. But in December of 2020, last year, the government launched a consultation paper exploring potential reform to the use of restrictive covenants, particularly non-compete clauses, which, as we've heard, sort of restrict the ex-employees from working for a competing organization for a period of time after termination. And this is something that's quite concerning for business and could be considered as quite radical. So the key reason for this proposal or consultation is to try and balance out some of the negative effects of unemployment and on the economy of the past sort of year as a result of COVID, but also to support further innovation and increased competition within the marketplace. So the paper, the consultation paper, proposed two main alternatives to the current system, and so I'll talk about both very briefly. The first was the introduction of a legal requirement that employers compensate employees for the duration of the non-compete clause, and possibly also non-solicitation, non-dealing, non-poaching, and goodwill protection clauses. So a similar system to this does exist in some European countries like Italy, France, and Germany. The proposal is that this might be a percentage of a weekly wage. So somewhere in the region of, it could be between 60% of a weekly wage and 100% of a weekly wage. And attached to this would be a requirement for transparency, which would state that the employer must disclose this clause at the start of the employment with the employee, and also there must be a maximum period of time at which would apply. And the proposal is anywhere from sort of 3 to 12 months. And as we've heard, the lengthier the restrictions, the more expensive it would be for the employer under this regime. So these proposed changes could have a dramatic impact on many businesses. We know that effective research and development relies on capital, trial and error, long lead times, and so non-compete clauses can provide additional security to the broader innovation process within an organization. And indeed, a significant proportion of employers will be able to point to cases where individuals have left the organization and taken clients or employees and set up a business in direct competition, drawing upon research and intelligence from their previous employer. And while we've heard there are other ways to navigate some of those risks, this is quite significant as well. So while other post-termination restrictions may be in force, like non-solicitation of clients, they can be difficult for employers to police and to enforce in practice. And in many situations, non-compete restrictions can be one of the only ways an employer has of protecting its own legitimate business interests. So we conducted with a very large number of IoD members and worked very closely, in particular with our Future of the Workforce Expert Advisory Group. And so this is a group of members who are particularly engaged in this area of work on behalf of the IoD to build our response to this consultation. I'd be very happy to share a copy of our response with anyone that might be interested, so please do get in touch if that might be of interest. But to summarize, we believe that employers should have the ability to waive a non-compete clause without the need to pay compensation. So while the employee may have entered into the contract based on the prospect of future compensation income post-termination, they are effectively reimbursed by the ability to more easily enter self-employment or start work elsewhere. And on the subject of introducing a maximum limit on the period of non-compete clauses, this could certainly provide additional transparency about what will be enforceable. A period of 6 to 12 months would be closely in line with existing case law, with 12-month restrictions generally only being enforceable for the particularly senior employees. And it may be an acceptable limit, but individual firms will have varying needs based on their operations and their IP, and greater transparency amongst employees will also avoid mandating limits. So the second more radical approach that was presented as part of this consultation is a complete ban of non-compete clauses altogether, which is actually the case in California. We believe that's a lot less likely, but we are yet to learn more following the closure of the consultation period. And so the consultation ended on the 26th of February this year. And so really it's a case of watching the space at this point. The government will need to take time to look at all the responses, to respond, and to look at how they can make any changes that they're going to seek to make. But this could have a really significant impact on business if it is taken forward, and could really change the way in which organizations can protect their legitimate business interests. So we'll continue to work to represent the views of members on this issue, and we will of course keep members informed as we learn more following the government's output from this consultation. So that's really it from me. As I said, if anyone's interested in a copy of our response, please do get in touch and I'd be very happy to send that across. But now I'm going to hand back over to Scott for today's Q&A.
Great. Thank you very much, Joe. And thank you also to Vicky and Adam for running us through the session. I hope that's been useful for everybody. There's certainly some really good learning points in there for everyone to take away. We've just got the one question arising from today's session, and it regards, I guess, the parameters of any type of restriction that may have or may be forced, and whether or not there's flexibility there for the court to make decisions to change those restrictions. The example given in the question talks of a 10-mile radius exclusion in terms of someone working within that geographical range being reduced to a 5-mile radius, and would that still apply? And does the ability to actually make that change? I guess that's one for you, Adam.
Thank you. It's a good question. Fortunately, there's an easy answer to that. The court will either enforce a restriction or will refuse to enforce a restriction. It won't rewrite it. And so if the restriction is considered to be too broad, then it's invalid, and that's it. So that's gives rise to an important learning point, which is that the restrictions really need to be very carefully thought through. They need to, if anything, err on the side of on the conservative side rather than the expansive side, to avoid exactly that sort of problem.
Great. I hope that answers the question. That one was put to us by Paul. We don't have any other questions, so I'm going to extend thanks again to the speakers who provided the session. I'm going to hand over to Nigel just to close down. Wish you all a pleasant afternoon, and we'll see you again soon. I'm just going to hand over to Nigel for closing remarks.
That's great. Thank you, Scott. Yeah, I found it a fascinating topic. I mean, Vicky opened up about why we have them, and I did take from that it's all about protecting legitimate business interests. So that phrase about legitimate is one that we all have to bear in mind. And then Adam expanded on that. Really, I was struck, Adam, by the courts are cautious about the way they enforce these things, and the phrase about don't get drawn into a battle of egos, it could get very expensive, is a very salutary takeaway I took from that. So, and then finally, Joe, excellent. Thank you very much for sort of summarising where we're up to on the government consultations. And you did say that the IoD response is available. How would people get that? Does that?
Yeah, absolutely. If people would like to send me an email, then I'm very happy to respond with a copy of that. We'll also be posting it on the website, so it'll be available there in time as well.
Yeah, and the consultation's closed now, I think you said. Is that? Yeah.
Yeah.
So very much a watch this space, see what the government thinking is on that, and how much they take on board the IoD's representations, really. So that's very useful. Thank you for that. So it's a thank you to everybody who's attended, much appreciated, and a final thank you to Rix and Kay and yourself, Scott, for sponsoring the event. I think it's been really, really useful. I will put a post on LinkedIn actually, because this is recorded, this event, and so people who couldn't make it, IoD members who couldn't make it to this, will be able to access it through the recorded messages. So thank you very much for that, and thanks everybody for your participation.
Just before, sorry, Nigel, just before you sign off, sorry to interrupt. We just had one other question come in. Can I pick that up very quickly? Just
yeah, of course.
Whilst we're here,
Yeah.
it's from Julian Burrows around redundancy and enforcement of covenants, particularly in the current climate, obviously with the backdrop of the pandemic. I think perhaps that's one for Victoria, is it?
So what was the question?
So can you provide some colour on redundancy and the enforcement of covenants, particularly in the current climate?
Sure. We are actually seeing more and more requests from people that are being made redundant as to whether there can be some form of relaxation on the covenants or outright waivers. There's no obligation to do that as a starting point, but many employers are seeing if there's some kind of middle ground perhaps that could be achieved. So whereby if you've got a robust confidentiality policy already in place, or you've already got non-solicitation, non-dealing clauses, you may perhaps think middle ground might be to say, well, we'll waive or reduce the non-compete, so that they do then have the individual has been placed at redundancy, not of their own volition. Then you might just want to be able to assist them, so that they're free to go to a competitor so long as they've got the other covenants in place. So maybe that's what we're seeing a lot more of, is just to see if there is some kind of middle ground, but essentially there's no outright obligation to do that.
Lovely, thanks, Vicky. Just to add before I hand back to Nigel to close off, if any of the attendees want to drop either Victoria, Joe, or Adam an email or pick up the phone, and I'm sure they'd be delighted to have a chat about more of these issues. So yeah, thank you for that. And yeah, just back to you, Nigel. Sorry about that.
No, that's good. Thank you, Scott, and thanks for the question. It's useful to if we get those coming in at the end, that's useful. So thank you very much. Yeah. Okay. Well, it just remains for me to wish you all a good rest of the day, and thank you very much for everybody joining the webinar. So thank you. Bye.
Thanks. Bye.